Every democracy has these defining moments, right? These flashpoints that really shape what it means to be free. Well, today we're jumping into one of those moments from Ghana, a massive legal battle that forced an entire nation to ask, what does freedom of protest actually mean? So, picture this. It's 1993. Ghana has a brand new constitution, and the ink is barely dry on all these promises of fundamental rights and freedoms for its citizens. But there's a problem. A law from an older military era is still on the books, and it's about to put those new promises to the ultimate test. And this really gets us to the heart of the whole conflict. It boils down to one simple but huge question. Is freedom of assembly a fundamental right you just have, or is it a privilege that the police get to grant or deny? That was a question at the center of everything. Okay, so what exactly lit the fuse here? How did this issue reach a boiling point? Well, it all started with a series of events that looked a lot like a pattern of official obstruction. So in early 1993, the new Patriotic Party, or NPP, just kept hitting a brick wall. First, they get a rally permit in Sekondi, but then it's suddenly pulled. 10 days later, they organize a peaceful demonstration in the capital, Accra, and the police break it up. And then, literally the very next day, a rally they planned in Kibi gets banned on the same day it was supposed to happen. You can see what's happening here, right? A clear pattern was emerging. So the NPP decides enough is enough, and they take this fight all the way to the Supreme Court. The stage was set for this incredible legal showdown, pitting an old, restrictive law against the nation's new supreme law, the Constitution itself. And here's the clash, plain and simple. On one side, you have the Public Order Decree from 1972, a law left over from a military government that says you must get a police permit for any public protest. But on the other side, you've got the brand new 1992 Constitution that flat out guarantees the right to freedom of assembly. No ifs, ands, or buts. These two things just couldn't exist together. Something had to give. So let's step into the courtroom. Both sides laid out their arguments, and they really get to the very core of what it means to live in a free society. The NPP's argument was simple, but so powerful. They basically said, look, if you have to ask for permission to use your right, is it even a right anymore? They argued the police permit was an unconstitutional prior restraint, which just means it stops free expression before it can even happen. The key point was this: if the police have the power to grant a permit, they also have the power to deny it, and that puts a fundamental right at the complete mercy of the authorities. Now, the government had a different take. They argued that no right is absolute. They saw the permit law as a reasonable restriction that was just necessary to maintain public order and safety, something they claim the Constitution actually allowed for. From their point of view, the police needed this power to manage demonstrations and prevent things from spiraling into chaos. So there you have it, two powerful, competing visions of freedom clashing in the nation's highest court. The entire country was holding its breath. How was the Supreme Court going to rule on this? And the verdict? Wow. It was decisive, and it was historic. In a completely unanimous decision, the Supreme Court declared that the parts of the old law requiring police permits were unconstitutional. They were null, void, gone. Just like that, the right to protest in Ghana was officially free from needing a permission slip. And the court's logic was just crystal clear. Justice Amuaseki really captured the essence of it, saying, whoever has power to grant a permit has power to refuse it. He said that kind of restriction would make the right to assemble meaningless and a sham. In other words, if someone can tell you no, it was never really your right to begin with. So the court officially labeled this permit law as a form of prior restraint. It's a key legal idea, but it's pretty simple. It just means the government was stopping speech and assembly before they could even happen. And that was a direct smackdown of the fundamental freedoms guaranteed in the new Constitution. To really capture the huge mental shift this required, Justice Amuaseki used this incredible analogy. He wrote that after so many years of restrictions, it was like the nation was a bird in a cage. And now, the door had been flung wide open, and it was time for the country to stop huddling in the corner and finally learn to fly free. So what was the real, lasting impact of this decision? Well, it was about so much more than just getting rid of one bad law. It was about shedding the skin of an entire past era. Chief Justice Archer really hit the nail on the head when he called the permit law a colonial relic. He asked this devastatingly simple question. The people who brought this law to Ghana, they don't have to get police permits back in their own country. So why should we? It was a rule for subjects, not for citizens of a free and independent nation. So when you add it all up, the legacy of this case is just immense. First, it cemented the 1992 Constitution as the undisputed supreme law of the land. It made it crystal clear that fundamental rights are yours by birthright, not things the police can hand out. And crucially, it took away a huge tool that could be used to shut down political dissent, making the right to peaceful protest a true pillar of Ghana's democracy. And that leaves us with a question that, honestly, every single democracy is still grappling with. The court's decision was a huge victory for freedom, but the government's concerns about public safety are still real. This case drew a very clear line in the sand for Ghana. But that tension between our liberty and public order, well, that's a conversation that never really ends.